Madam Justice Ketanji Brown Jackson tries to rewrite the Constitution in oral argument. Good afternoon, ladies and gentlemen. This is another declaration of truth from your host, Terry A. Hurlbut. The Supreme Court of the United States opened its 2022 term this week. On Tuesday, October 4th, the court heard oral argument on two cases. The more important of the two is a consolidated case involving redistricting in Alabama. And in that argument, Justice Ketanji Brown Jackson clearly showed her intent to rewrite the Constitution and history. She can only be doing this, furthermore, in the furtherance of critical race theory. Before I take the deep dive into her argument, I do want to shout out to the prime sponsor of this channel, which is Conservative News and Views, link in the description. Be sure to check out the awesome CNAV Store. Scroll down near the bottom for that link. Lots of great merchandise there, especially this t-shirt that I've chosen for today, which depicts Plato saying, "No one is more hated than he who speaks the truth." One more thing. If you like what you're about to hear, you can like this video. You can also click the bell icon to get a notice every time I come out with a new one. In fact, do you see the new icon, the heart shape with the US dollar sign in it? That's the super thanks icon. If you really want to keep these videos coming, click that and leave me a tip. Any currency will do. All right. Class, Constitution 101, or maybe make that Constitution 125, how not to interpret the Constitution, is now in session. The case, or rather two cases, are Merrill versus Milligan, docket number 21-1086, and Merrill versus Caster, docket number 21-1087. In them, Mr. John H. Merrill, Alabama's Secretary of State, is defending a new House of Representatives district map that the legislature drew. Two different activists named Evan Milligan and Marcus Caster sued the state and demanded that a court substitute their district maps. Alabama's legislature drew those districts in a race-neutral manner. That is, they enforced no preference for members of any given race being shoo-ins for election from any given district. That wasn't good enough for Messrs. Milligan and Caster. They want proportional representation of whites and blacks in Congress from their state. To do that, they insist on drawing a map so that if 27% of the state's residents are black, so also will be a quarter of its U.S. House delegation, meaning, in this case, 2. Milligan and Caster have made a very foolish argument. Legislative districts should be about neighborly relationships, not about what proportion of the population has skin of any particular color. And in addition, there is only one race, the human race. Milligan and Caster might as well ask the state to, first, apportion House seats explicitly according to race, and then, second, hold at-large elections among whites and blacks separately to choose white and black candidates to fill the slots. Indeed, an organization calling itself FairVote proposes something very like that. I have a link to the description of their proposal. Now, at least their proposal would let you choose where to align. You would vote for the Republican Party or the Democratic Party, two different candidates for Speaker of the House. Then, the Secretary of State would apportion congressional slots in proportion to each party's showing in a statewide vote. That is how they do things in many European countries and in the state of Israel. And the late Paul Eidelberg, who was a resident of Israel, railed against such proportional representation and argued for single-member districts. Single-member district representatives are accountable to their neighbors. Proportionally assigned slot holders are not. But Milligan and Caster want to go further even than that. They want to align people by race. And when they can't get their state to change its constitution to send people to the House of Representatives in such a manner, they do the next best thing. Their older brothers lobbied for the Voting Rights Act, and that allegedly mandates the drawing of districts to achieve proportional representation by race. And that violates the 14th Amendment. The 14th Amendment reads, in relevant part, no state shall make or enforce any law which shall abridge the privileges or immunities of citizens of the United States, nor shall any state deny to any person within its jurisdiction the equal protection of the laws. Now, Mr. Edmund LaCour, Alabama's Solicitor General, stepped up on Tuesday to argue that point. And that is when Ketanji Brown Jackson completely botched the 14th Amendment. The Supreme Court's website has the transcript of the oral argument, and I have a link to that transcript in the description. Now, page 52, Justice Amy Coney Barrett steps up to question Mr. LaCour on the dual considerations that he faces. First, she acknowledges that Alabama would not have two majority-minority districts without a deliberate attempt to account for race. Then she makes sure she infers correctly from Mr. LaCour's argument that, and I quote, if you were forced to adopt a map proposed by the plaintiffs that was racially gerrymandered because race was predominant in its drawing, then you would be violating the 14th Amendment. Unquote, Justice Barrett. Mr. LaCour answered yes. He further denies that the federal government has any compelling interest in such proportional representation by race. Then, go to page 57. Justice Jackson twists the 14th Amendment beyond any semblance of its original meaning. Settle in, ladies and gentlemen, because this will be a very long quote. Why, she says, given our normal assessment of the Constitution, why is it that you think there's a 14th Amendment problem? And let me just clarify what I mean by that. I don't think we can assume that just because race is taken into account, that necessarily creates an equal protection problem. Because I understood that we looked at the history and traditions of the Constitution and what the framers and the founders thought about, and when I drilled down to that level of analysis, it became clear to me that the framers themselves adopted the Equal Protection Clause, the 14th Amendment, the 15th Amendment, in a race-conscious way. That they were, in fact, trying to ensure that people who had been discriminated against, the freedmen, during the Reconstruction period, those are her words now, were actually brought equal to everyone else in the society. So I looked at the report that was submitted by the Joint Committee on Reconstruction, which drafted the 14th Amendment. And that report says that the entire point of the amendment was to secure rights of the freed former slaves. The legislator who introduced that amendment said that, quote, unless the Constitution should restrain them, these states will all, I fear, keep up the discrimination and crush to death the hated freedmen, unquote. That's not a race-neutral or race-blind idea in terms of the remedy. And even more than that, I don't think that the historical record establishes that the founders believed that race neutrality or race blindness was required, right? They drafted the Civil Rights Act of 1866, which specifically stated that citizens would have the same civil rights as enjoyed by white citizens. That's the point of that act, to make sure that the other citizens, the black citizens, would have the same as the white citizens. So they recognized that there was unequal treatment that people based on their race were being treated unequally. And importantly, when there was a concern that the Civil Rights Act wouldn't have a constitutional foundation, that's when the 14th Amendment came into play. It was drafted to give a constitutional foundation for a piece of legislation that was designed to make people who had less opportunity and less rights equal to white citizens. So with that as the framing and the background, I'm trying to understand your position. That's Section 2 of the Voting Rights Act, which by its plain text is doing that same thing, is saying you need to identify people in the community who have less opportunity and less ability to participate and ensure that that's remedied, right? It's a race-conscious effort, as you have indicated. I'm trying to understand why that violates the 14th Amendment, given the history and background of the 14th Amendment. Unquote, Ketanji Brown Jackson. Now, Mr. LaCour protested that the 14th Amendment forbids discrimination against anyone by the government, and the key, that amendment does not oblige or even allow the government to engage in affirmative discrimination in favor of some groups vis-a-vis others. And Jackson, incredibly, said in effect, oh yes it does. She also said that the Civil Rights Act of 1886 does the same as Section 2 of the Voting Rights Act. There's a lot to unpack here. Before I start the unpacking, I want to shout out to a sponsor who can really help you through the economic storms to come. That sponsor is oursilverlions.com. Do you feel like you're working harder for your money just to get by? You're not alone. Our fluctuating economy, employment changes, life changes have left many families struggling over the past 3 years. Collecting gold and silver can help shield you against many of these challenges, but if you're like me many years ago, you don't know where or how to start. Our Silver Lions helps by connecting you with thousands of members who are learning the secrets of learning the secrets to creating and protecting true wealth by collecting precious metals. Now, maybe you just want to collect rare and unique coins, or you're an entrepreneur. You're looking for business opportunities? This company has got them. Either way, they can help you learn to live an exceptional life. Visit oursilverlions.com to learn how you can build a legacy for your future. Excuse me. Now, the unpacking. Jackson J. said, in essence, that the 14th Amendment gives full license to proportional representation by race in the United States House of Representatives, and so did the Civil Rights Act of 1866. No, Madam Justice Jackson, that act does no such thing. And if any of you listening to me now doubt that, I've left a link in the description to a page having the full text of that act and a discussion. I repeat, defy anyone to find one word in that text which says or implies that equal protection of the laws means a guarantee of proportional representation in Congress by race or by any other criterion. Nor did the report of the Joint Committee on Reconstruction show any intent of or justification for discrimination against whites. Jackson states that the purpose of the 14th Amendment was to secure rights of the freed former slaves. That does not mean depriving anyone who wasn't a former slave of either life, liberty, or property without due process of law or equal protection of the laws. The only part of the 14th Amendment that anyone can possibly construe to do either thing is Section 4. That section invalidates the Confederate war debt and makes the value of lost or emancipated slaves non-recoverable. The framers of that amendment made a judgment, the kind of judgment one can make only in a constitutional amendment, which is, no human being should ever have owned another. This follows logically from natural law, and everyone who ever owned a slave should have known this. and therefore no slave owner has any more right to recover losses from the emancipation of slaves any more than one who pays for stolen goods has any right to recover damages when the original owner of the goods demands them back. Beyond that, the 14th Amendment says that whites and blacks deserve equal treatment before the law. They have equal standing in the law courts, a thing Chief Justice Roger Taney denied to Dred Scott, and that flawed ruling started the war between the states. The 14th Amendment also says that any state that denies a large proportion of people the right to vote loses representation in Congress. The 15th Amendment makes that moot by making it unconstitutional to deny members of any race the right to vote. How is this not race neutral? If whites had no legitimate interest in denying to blacks the right to vote, they lose nothing under this amendment. Now, I said back when Ketanji Brown Jackson won confirmation, thanks a lot, Mittens and Lisa Murkowski, she who hears voices in her head, that Jackson is not qualified to sit on the Supreme Court. Why? Simple. Jackson, like Kagan and Sotomayor, ascribed equity powers to the Supreme Court. Except in admiralty and maritime cases, or when a state is a party, the Supreme Court has no equity powers. Equity powers are powers of courts of original jurisdiction. In this case, the court has only appellate jurisdiction. She has already declared her allegiance to critical theory, of which critical race theory is a subset. Critical theory says, in sum, that straight, white, cisgendered males must suffer losses of property and representation in Congress, if not of liberty or even life, to make up for past real or imagined wrongs that straight, white, cisgendered males allegedly did. Hence, her interpretation of the 14th Amendment. What she is really holding out for is equality not of process of law, but of outcome. That alone justifies proportional representation by race. She also assumes, without warrant, that one's personal, legal, and political interests follow from race, gender, and other identities. That is the basis of social credit. Therefore, any black who votes for a white betrays his race. And a white voting for a black man? Not possible, unless these are the only choices available. The Reverend Dr. Martin Luther King Jr. would be the first to correct her on that if she would listen. Else, why, in encouraging the actress Nichelle Nichols to stay on the set of Star Trek, did he say, and I quote, "For the first time, we are being seen the world over as we should be seen," unquote, Martin Luther King. And how did Nichelle Nichols portray black people in Star Trek? As the full equals of whites and members of any other race. And she showed something else, that philosophical and political alignments need not depend on race. Ketanji Brown Jackson assumes a priori that they must, and so the president has ensured that the Supreme Court will have many stormy terms to come. More to the point, Ketanji Brown Jackson wants not race neutrality, but punishment of whites, and she made clear that she will get it if she has to rewrite the Constitution to do it. Link in the description of the article to the FairVote plumping for proportional representation in Congress, to the transcript of the oral argument at the Supreme Court, to the text and discussion of the Civil Rights Act of 1866, and to conservative news and views. I've also left links to the awesome CNAV Store and to oursilverlines.com, as I also mentioned. You know already about how to like a video, turn on notifications, and leave a tip. On the end screen, I'm going to leave a subscribe link and links to my earlier video about Justice Jackson, to my eulogy of actress Nichelle Nichols, and to my look ahead to another Supreme Court election law case that hasn't come to oral argument yet. This is Terry A. Hurlbut delivering another declaration of truth and reminding you to let the truth set you free.